of the CLE was I was thinking back when I was in grad school, we used to sit around and read a poem or a short story or a chapter of a novel and go line by line through it and discuss it. And I wondered if such a close reading would work for case law. And then I saw a tweet by a post from Emily Brenner, she teaches at Notre Dame Law School, and it said that it can't be overstated how valuable it is to reread the full unedited version of a case. And so I thought, well, let's just try it with a case. And I've been collecting cases on summary judgment, and just seems like there's so many trap doors in that area of the law. And I thought that was a good case, simple case, stands for a bright line proposition, got some trial rules in it, some case law. So I thought, let's go with that. And so if you tell me, hey, Telloyan, that's as boring as heck, let's never do that again, that's fine as well. And we'll just can this idea, but there might be some value in it. I was talking with Nell Newton the other day. She is former dean at Notre Dame Law School, and she said the key to success is surrounding yourself with people who are smarter than you. And so I've sought to do that this time. And I've asked Ian Flora and Ian Septoski to join me. And basically I'll be the moderator and the reader, and we'll get Ian and Ian to chime in. Ian Flora, can you give us 30 seconds on your background, where you're from, where you grew up, where you went to school?
I'm from South Bend. I went to Stanley Clark, then Marion, then IU Bloomington, then IU Indy, and then graduated and came to work in South Bend, which is where I got to know many of you folks. And then eventually ended up switching from mostly doing debtor work to creditor work. And at this point, I consider myself a solo practitioner, creditor's rights attorney. I have kind of a unique practice where all of my clients are other law firms or debt buyers or lenders or something like that. I have no private clients. And essentially, I handle litigation and basic courtroom procedural work throughout the state of Indiana. At least one time I've been to every courthouse in the state. To get a courtroom I haven't been in, you'd have to get down to some small city courts and town courts, and most of them I've been to at least once.
Interesting. Very good. Ian Septoski, can you give us 30 seconds on your background?
Sure, yeah, thank you. I grew up in New Hampshire, moved to Indiana when I was in high school, went to Purdue for undergrad, Valparaiso for law school. Today, April 18th, 2024 is actually my 19th anniversary of with Kreiser and Associates, basically doing almost 100% collection law over that time. In the last 3 or 4 years, 100% collection law throughout Indiana. I've also been to, as far as I know, every courthouse in Indiana, and also I practice in Michigan, so a good portion of Michigan also.
Very good. Thank you. Welcome. 30 seconds on my background. Graduated from Notre Dame Law School in '98, clerked for a local judge, Sandy Brook. Had a teaching fellowship in Ireland at a law school there, taught legal research and writing and legal and business ethics. Then I was a deputy prosecutor for 4 years, started out in child support, went to major crimes, then thrust into the cold, cruel world of private practice. Law partner was Jamie O'Brien. I had general practice for 10 years, did everything that came through the door. And then the last 10, I focused on bankruptcy, primarily consumer bankruptcy. Also taught the bankruptcy class at Notre Dame Law School. When I had a gnarly problem, Ian Flora was the one I called, so I know Ian from way back. So Cheryl Welton, appellant, defendant, v. Midland Funding LLC, assignee of Chase Bank USA, issuer of a Disney consumer credit card. I guess that makes this a Mickey Mouse case. Assignee of credit card account brought collection action against the cardholder. Ian and Ian, tell me how this assignment process works. Is it a public sale? Can anyone buy the debt? How does it get papered? Who keeps the records, etc.?
Well, Mr. Flora said he represents some debt buyers, which I don't do, so he probably knows more about this than I do.
Yeah, and unfortunately, as to that question, that's a little slice of the apple I don't usually see. Midland Credit Management is one of my clients. they are buying these in kind of mega bundles, almost like how somebody would purchase a stock portfolio, which is why you see them filed in your case with every other account in a bundle, basically redacted. I don't know that what they are doing is something that anyone in the public can just go and do. I'm not sure exactly how that level of it works. As a general rule, as far as debt buying, basically anybody can assign a claim that somebody else has a legal right to and can sell it to anybody. So stepping back from the biggest level and then assuming it has to some extent work at that point, you know, I have seen things where like I've had a judgment against a defendant. The defendant's family member might be an attorney or something and come in and buy out and settle our judgment and then do an assignment to themselves to take the right to collect out of that judgment. There are people on this phone who work for companies who buy debts in a myriad of different ways, and they're a lot smaller than Portfolio Recovery or Midland Credit. So some of them might have a better insight on how that works. I would kind of mention here that in none of our materials today, I think, do we have anything on duty versus CIT? I don't have because I'm using my phone where I keep all of my citations to on it. I can't look it up right now, but if the people on the call aren't familiar with duty versus CIT, it's a pretty important case in the debt buying law, because one of the issues that held up courts was often the defense in these kind of cases is essentially, you know, my client had a contract with Capital One Bank. I don't know who Midland Credit is. And I mean, Ian can probably speak on this too. I mean, that was kind of a bane of our existence for about a decade, was fighting those kind of cases, making sure we had all of our transfers, assignments, and bills of sale. And then in 2017, the Court of Appeals in this duty case, which I believe was actually out of a foreclosure, kind of eliminated the assignment issue by essentially finding that the defendants in the case, since they weren't part of the assignment contract, didn't have standing to be challenging those contracts short of having some indicia of actual fraud or something like that. So unfortunately, I don't have a better answer on how the biggest players in the industry buy debt, but kind of to recap the answer, essentially anybody can buy debt as long as the underlying debt was something that was collectible in the court.
Any idea how much it costs to buy bad debt?
The answer to that is across the board and would depend on the quality of the paper that's being bought. You know, the term that's always thrown around is kind of pennies on the dollar. To some extent, that is true. But I think it depends on how much and the nature of the debt. Buying massive credit card debt where you're buying billions of dollars for hundreds of millions of dollars, yes, that's a pretty big markdown, but that's not a level that you and I or 20 friends investors can get into. Right. You know, if you're buying signed written contract paper from a retail lending outfit or something like that, that's got a copy of the original signatures, it's got the borrower's a pretty recent address and employment information, you know, that stuff might be worth more like 50 to 60 cents on the dollar because it's highly collectible. As far as what it's bought and sold for, though, it does depend on the type of debt, how old it is, et cetera, et cetera.
Thank you. My last question was, is it all automated or are there humans involved in this?
Well, I'm the debt buying process itself. I don't know about the debt buying process itself. If you're talking about compiling the information to essentially put together an affidavit of the debts, which happens in the non-buying debt world too. And that information is important when it comes to debt buying and the assignment process. And my perception is that people are at least looking at that level at that level to do that due diligence.
Very good, thank you. Superior Court, Marion County, Patrick J. McCarty granted assignee's motion for summary judgment and the cardholder appealed. I'm curious, what's the percentage rate of summary judgment grants? And in our court, we require an in-person hearing for summary judgment. Is it like that in other parts of the state?
In my experience, over nearly 20 years and tens of thousands of cases, the rate of summary judgment grants is extremely high. As well, I think it should be, because most of these cases are relatively simple. having a substantive defense to a collection case in the credit card realm, or maybe even the medical debt realm, which I'm familiar with, is not a very high percentage of substantive defenses in those cases. As for your case, I have a question about having an in-person hearing. The trial rule only requires a hearing, basically, I think if one party requests it still. And I think most courts have moved away from requiring an in-person summary judgment hearing.
Ian Flora.
As far as the in-person summary judgment hearing, yeah, the vast majority of courts don't. And I mean, the first decision tree is kind of, is there a responsive pleading or not? If there's not a responsive pleading, then very few require an in-person hearing because there's not much to be gained from that. I will say it tracks a little bit with bigger and smaller county kind of issues, and it can be a little bit judge specific. In your larger counties that have more robust local rules, like Lake County, where I'm sitting now, and I believe St. Joe County had something like this, but in Lake County, they have a local rule that essentially says any motion before the court can be set for hearing. So they set most motions in Lake County kind of because of that rule for hearings. I guess my position on the summary judgment is trial rule 56 is kind of unforgiving on the deadlines for responses. So if you set a hearing and there hasn't been a response to that, what is the court going to hear that it should be allowed to hear? Because I mean, we're kind of assuming in these cases that they're unrepresented. If they're represented, they're going to have a response, and then there's just kind of more of a requirement for hearing. I will say, practically speaking, I don't have an objection to those being held in person, because a lot of times when they are, even if there's no substantive issue and judgment is just going to be entered that day, from representing my client standpoint, is kind of a free proceeding supplemental. You get an opportunity where a defendant might show up and talk to you about resolving the case that otherwise you wouldn't get them in the courthouse, and you can kind of hear what the issues were with the case. I mean, the reality is, Judge, you're having to ask that question now because, you know, with the rise of the Reddit websites and the internet, we are seeing way more in the last 5 years than we ever did in our practice, folks receiving the complaint, and instead of doing nothing if they owe it, or if they want to get involved with the case, a general denial. We're seeing these shotgun approach, printed off the internet, a lot of times still with the website they printed it from, at the bottom of the page. That's every affirmative defense that can be imagined, and latches and collateral estoppel, et cetera, affirmative defenses and counterclaims and everything else. And then unfortunately, we have to file more summary judgments than we used to over a case where ultimately when the person shows up, yeah, I owe it. The internet just told me to file this thing. And if you ask them what latches is, they have no idea.
Right.
But in general, you know, I guess my answer differs a little slightly from other Ian on the how many are granted. In my experience, you know, percentage, almost all of them are granted, because the vast majority of them don't have a response or raise any kind of issue. But I would say, in a real world sense, the amount that are set for hearing and the defendant or defendant's counsel appears and essentially is contesting it in any way, the vast majority of courts in that setting just kind of fall back on the, well, you know, Indiana is in favor of going to trial if there's any issue. And I mean, you know, we can point to case law and court of appeals that say, well, if the issue they're raising is balance or something, then the summary judgment and the response thereto, along with filings, should tell us what they think the balance is. So in theory, at the summary judgment, we can rectify it and be done with it. But boots on the ground stuff, which is all I do, being in courtrooms arguing these kind of things all the time. Essentially, if you have a defendant that walks in there and just says no, just obstinately says no on the case, most courts are not going to enter summary judgment and will set it for trial.
Holding the Court of Appeals, Barnes Justice held that. All right, so Mike Barnes from St. Joseph County, our longtime prosecutor. Met him back in 1995 when our law school group went to the prosecutor's office, impressed by both him and the cufflinks he was wearing. Held that the Superior Court did not abuse its discretion by denying credit card holders' motion for relief from summary judgment. and 30-day period for credit card holder to file a notice of appeal of summary judgment entered in favor of assignee of credit card account on collection action began to run on the date of the entry of judgment. All right, so here we have a small dollar amount, $4,000 or $5,000. How often do cases like this get appealed? And as a policy matter, do you think 30 days is reasonable?
So weighing in a little about that, over thousands of cases over the years, I've had exactly one that ever went up on appeal.
How
And that
many?
was one.
One.
And that was not even on the substantive merits of the case. It was a procedural issue about where a defendant tried to appeal the entry of default judgment without first asking the court to set the judgment aside, which also gets into what happened in this case a little bit. So just for that information, if in most cases, generally, if a default judgment's entered, a defendant must avail themselves of 60B and try to have it set aside before they can appeal it. And getting back a little bit to what Mr. Flora said about summary judgment, the other thing about cases going on to appeal is that really the only opportunity for that is if a summary judgment's entered or if a court enters a judgment after a trial. I think in most of the cases, I've tried hundreds and hundreds of cases at the small claims level, but when it comes to things like credit card debts, for my major client for whom I've been filing thousands of cases for nearly 20 years, I've had exactly 3 trials for that client. It doesn't happen very often that cases go to trial. What Mr. Flora alluded to earlier about getting these answers and affirmative defenses filed by defendants these days, there are groups out there, debt consolidation groups, debt settlement agencies who sign up people. They solicit defendants. They'll send them, they find that people are getting sued for a credit card debt. They send them a solicitation letter saying, we notice that Chrysler Associates is suing you. We can help you out with that. And then
we'll $500.
Yeah, and then we'll often get, I can tell which company this defendant is signed up with by the pleading they file, even before that company's ever contacted me. And so the vast majority of the filings that are being done by defendants in these cases are for the purpose of ultimately coming to some settlement agreement.
Affirmed. So Ian Septoski, on your one appellate case, was the trial court affirmed?
Yeah, it was. And again, there was just a case out of St. Joseph County in January of this year that kind of qualified this a little bit. But again, that case was just reaffirming that an entry of default judgment, the defendant has to avail themselves of 60B first.
60B first. Ian Flora?
I have also had in total one Court of Appeals case that was pretty recent, and it had to do with accord and satisfaction. So I don't know that it has much bearing on what's going on today, other than the general concept is you work in a collection law firm, make sure that your staff is aware of what accord and satisfaction is. And if you're cashing checks and somebody's trying to write paid in full or settle in full in the memo line, that you don't cash that check. And in that one, the trial court found in our favor. The Court of Appeals affirmed the trial court. Okay. There wasn't oral argument. It was just briefs. And so in a hyper-technical sense, I can say I won a Court of Appeals case, but it's not a very interesting one. But if anybody in the group wants to look it up, you can look it up by my name.
I will as soon as we're done. All right, here's the lawyers that were involved. Case summary: Cheryl Wilton appeals the denial of her Indiana Trial Rule 60B motion for relief from judgment granted to Midland Funding, LLC. We affirm. Issue: Welton raises 4 issues, which we consolidate and restate as whether the trial court properly denied her motion for relief from judgment. Facts: Welton had a credit card issued by Chase Bank with an unpaid balance of $45.18. What's the usual amount for lawsuits like this?
I would say that's pretty average.
Yeah, I mean, it really depends on the client. You know, if you're representing a local dentist or something, you're going to be seeing cases in the $500 to $1,000 all the time. Um, as far as Midland and your larger debt buyers that you've kind of been asking about, those generally run between 1,000 and 6,000 to 7,000. And then, you know, if you are representing Bank of America, American Express, some of those ones that hold their own debt, don't sell it to third party buyers, and tend to have larger credit card limits, tend to be small business accounts, that kind of thing, then those, you know, your average cases are probably well over 10 grand. I think Bank of America see a lot between $15,000 and $50,000.
Wow, wow, wow. The account was assigned to Midland. On December 7th, 2011, Midland filed a small claims action in Marion County to collect the debt, and the matter was then transferred to the trial court. Why was it transferred, and why small dollars like this are in anything other than small claims? And any idea what's going on here, the small claims and then the trial court? And also, do you have any preference as to which court hears your case?
Well, I actually looked at the case history a little bit this morning, and I couldn't figure out from that why it was ever filed in small claims. I can only speculate. One reason may have been that one of the parties wanted to avail themselves of broader discovery rules and had the case transferred to upper court. As you know, in small claims court, you need to have leave of court to conduct discovery. Right around that time, there was one of the hotbed issues. So debt collection attorneys not only are bound by Rule 11 of the trial rules and obviously ethical rules, but also federal law called the Fair Debt Collection Practices Act. Anyone who uses basically acts as a debt collector to collect the debts of another person is considered a debt collector under the FDCPA, and that applies to attorneys too. A lot of attorneys don't realize that. It even applies in eviction cases, for example. And the FDCPA also imposes not only penalties for violations, but as I said, a lot of additional requirements on us. Around that same time, one of the hotbed issues had to do with venue for the Fair Debt Collection Practices Act. There were some lawsuits pending about where a party can be sued. The FDCPA says that there's two venues where you can file a debt collection lawsuit, either where a contract was signed or where the debtor resides when the suit is filed. There's a 2014 Seventh Circuit case that came down that basically really limited that geographically, that the closest judicial district in which a party lives. And so what happened in Marion County was, because Marion County has all these split township courts, it was really difficult for anybody to decide to determine where this person lives in relation to one of the township courts. And so my office included, a lot of the debt collection attorneys started just filing in upper court in Marion County. We still do that to this day.
Interesting.
As for what court preferred, you know, if I can do a small claims case, I'll do that every day, just because it's, you know, it's quicker and easier.
Ian Flora, do you have a preference of small claims or upper court?
Well, I'd like to start by saying everything that Mr. Septoski said, I think is correct. And, you know, there was that Court of Appeals to the 11th Circuit in Chicago that really came down hard about getting those townships in Indianapolis and the ones that they lived in. There was a perception when that went up that people were picking, say, Lawrence Township over Pike Township to harass or be the farther away one from people. I was somebody that was doing volume filing in small claims court at the time that went up, and I'll tell you that picking which one of those townships you use had nothing to do with the defendant or the inconvenience to them. You were filing in such volume, you didn't care where their address was. It's that some of those courts worked and some of them were absolutely broken, and you wouldn't get initial hearings or paperwork through there. So people were all filing in the ones that had, you know, judges and staff that did their job. And that's what created that issue. Mr. Septoski was also correct that you have a number of clients, even though the balance of the case might be well below the line to be in small claims court, that the way they conduct their business, they do prefer to be in the bigger courts because they can do discovery, end up with a cleaner record, things like that, which at the mega scale, like the Midland Credit in this case, they have to, not only be compliant, FDCPA, they have the CFPB that is looking over their books and their shoulders all the time, making sure they're being clean and careful, and it's a little bit better to be clean and careful in the CC courts over the small claims courts. What do I prefer? A little bit like the point I made earlier about not complaining about extra summary judgment hearings, because it is an opportunity to face to face and extra time with defendants. I kind of think that's true on collections, that when you're in small claims courts, a lot of times that initial hearing gets turned into a face-to-face meeting where you have an agreed judgment and a payment arrangement, and your whole case is basically taken care of that day. Now, that answer applies to Lake County, Allen County, St. Joe County, small claims courts. But, at this point, I think there's around 20 or so of the counties in the state that don't really do initial hearings anymore, because the small claims rules don't actually I know probably everybody here on this phone that's done small claims is used to the process where you file it, you get an initial hearing date, you set a gazillion of them, and then the ones that are contested and you can't work out that appear, you go get a trial date. But there's not actually an allowance for that in the small claims rules. That's just something that, practically speaking, has arisen in most larger volume small claims courts. But there are a larger and growing number of counties in Indiana that your small claims initial hearing is your trial date. So you are showing up on that date ready to go or not. And it still feels very Judge Judy and informal. So you're not necessarily precluded from victory if you don't bring a witness with you. But I mean, I've seen that expand from very small rural counties like Owen County to now Hancock County, which is Tyler County to Indianapolis, and where Greenfield, Indiana is. I mean, they're like that now too. So this is a long-winded way of saying that can create a whole nother set of obstacles for my client. Because if my client's Midland Credit and they are wanting to have a witness available at trial to authenticate their documents or something like that, if we're in small claims court, that's different than a CC court where these are being scheduled a trial 45, 60 days later. You can get airfare and a hotel, et cetera, as opposed to a small claims court. And just every time Hancock County has a small claims call, you just have to have somebody sitting ready to go.
So that's what you call upper court, the CC court?
It's what I call it sometimes.
Complaint was filed on January 17th, 2012, and Welton failed to respond. So is this a second complaint, and is it a different form because it's in the CC court, as Ian Flora would say? And what's the percentage of defendants who fail to respond, and who transferred it to the trial court?
Well, as percentage of defendants who fail to respond, I think it's a very high percentage. I wouldn't be able to give you
80 or 90?
Well, I wouldn't be
at least.
surprised. Yeah.
95?
Yeah, if it wasn't pushing the upper 90s, then I tell you, everybody that's filing these in the upper court would be back to the small claims court.
Yeah. Any sense whether this was a second complaint, or just why do we have a second complaint?
My guess would be that if it was filing small claims first, they probably just wanted to beef up their complaint a little bit, which I think is normal. I would do the
List
same.
the facts and such. Default judgment was entered against Welton on March 15th, 2012. So 60 days later. Is that pretty typical?
Well, so I would say that generally that time frame isn't out of the ordinary. Especially in Marion County, you're looking at maybe a little bit of delay in service. So, I wouldn't say that that's out of ordinary at all.
Okay. On March 23rd, 2012, Welton filed a trial rule 60B motion for relief from judgment, in which she alleged that she, 1, had not received a copy of the complaint, and that 2, the obligation was satisfied 2010 in a compromised amount. Ian Flora, I know you love trial rule 60B. What are you thinking when you see this sentence?
Well, I remember 60B was something, motion to set aside the default judgment was something I might see once a month for the first 15 years of my career, and it is something I see 2 or 3 times a week now. I again would probably blame Reddit for why I see this way more than I ever did before, but also
Reddit, the website.
well, that and there's a number of courts where proceeding supplementals are done on the record, and I think in a attempt to give some hope and end the hearing that maybe materials that are available in the courthouse or judges overstep a little bit, and it's essentially to a point that it comes off like a recommendation for this. Now, certainly there are times when it's appropriate when the defendant is saying orally in open court things that match with the 60B motion. There are Court of Appeals cases that are a little bit confusing on one point of it, which I guess I'll jump right to, and that is if you have no service. So
okay, let's wait on that. We're going to look at the trial rule in detail. All right, so here we have Rule 60, relief from judgment from order, mistake, excusable neglect, newly discovered evidence, fraud. A motion, and upon such terms that are just, a court may relieve a party from a judgment, including a judgment by default for the following reasons. And here we have the 8 or so reasons. I won't read them all, but go ahead and jump in, Ian Flora.
Well, something that I wish was more bright lined, and maybe Ian Septoski feels that it is, I think a lot of people would say there's kind of 2 elements to the functional part of 60B now. Essentially, you're faced with somebody who is saying, 1, there was no service on the case. Now, defendant's counsel is going to argue that's all that matters. That if you show that there's no service in the case, that your judgment is void. Now, I try to use my brain and speak English, and there's a pile of cases that tell me that 60B 1 through 6 require a showing of a meritorious defense.
All right, let's look at that.
And the Court of Appeals likes to keep reiterating this meritorious defense. So my question is, if non-service is a void judgment and not voidable, then why are we spending any time worrying about this meritorious defense? So it is my opinion that a 60B essentially has 3 elements. The first is timeliness, and that has a lot of sub-elements to it. The next is a showing of non-service. And with the non-service, that is an evidentiary issue with a standard of more likely than not. Because when I lose these, it tends to start and end with a defendant saying, I didn't live there, court saying, okay, and throwing out my judgment. And then also, the Court of Appeals has reiterated 7 or 8 times now in the last 2 years that 60B 1 through 6 needs a meritorious defense. Nothing tells us exactly what that means, but I think logic dictates that that should be enough of a defense to the case that it would essentially survive summary judgment. And the issue, and the purpose of that whole thing being is courts are commonly thinking that it's helping the defendant to throw out these over the service issue, not looking at the meritorious defense issue and forgetting that our post-judgment interest in Indiana is 8% per annum, as opposed to the contract interest rate on a lot of the loans and credit cards and things that I deal with that are as high as 30% or more. So, I had a case in the courtroom next door to you in St. Joseph County, and they had an attorney on this set aside the judgment. And it was the same issue, showed that there was no service. Court took it as void instead of voidable, never got into the meritorious defense. This case was 10 years old. So it started as $10,000 credit card. At 10 years, 8% per annum, that's basically gonna double by the time this person either got a bank hold or a notice of pros-up and was dealing with it. So now they owe $20,000 that they're coming in to pay on this case. They hire an attorney in South Bend. He gets their case set aside. Fantastic. We're back to starting the case all over again. Goes to
20%.
summary judgment. No response is filed on summary judgment. Judgment is entered. Now that person's judgment is $33,000. So this person had a $20,000 judgment, hired an attorney, paid that attorney money, had their judgment set aside, had no defense to the case, filed no defense to summary judgment, and now owes $33,000. And I
Yeah.
see this happen over
I
and
see
over and
your
over
point.
again in pro se cases.
To get back to your earlier slide, Your Honor, 2 points that I think are important. You asked on one of the slides whether actual service was necessary, and lack of service is obviously one reason you can move to set aside a judgment. Service under trial rule 4 is requires either service by personal service on the defendant, certified mailing, or the sheriff to go out and leave a copy and then mail a copy afterwards.
Okay, so personal service, certified mailing, or the sheriff.
Yeah, exactly. Yeah. And what the realm I see most often, it would be where the sheriff goes out and leaves a copy at the address and then mails a copy afterwards, and the mail copy is then returned by the post office saying the person wasn't at that address.
Right, right. See that a
Now,
lot.
under trial rule 4, there's an argument to be made that that's still a valid service because the trial rule doesn't require that sheriff's mailing copy to actually be received. It only requires it to be sent. However, as a practical matter, if someone files that a motion set aside and alleges that that happened, I'm probably not going to, in most cases, object to it. It's just better to me to, I think, lay everyone's cards on the table rather than having those arguments. When it comes to the meritorious defense elements of required by rules, sub rules 1 through 4, and then sub rule 8, up until 2021, it was a very, very strict standard about what a meritorious defense meant. It meant that the movement had to establish with admissible evidence that the judgment would change if it was retried on the merits, and an injustice would be foisted upon the movement if the judgment wasn't set aside. It's a very high bar. The movement has to actually give the court admissible evidence that this judgment will change. In 2021, the Indiana Court of Appeals decided a case Logansport Cass County Airport versus Coconauer, which is 169 NE3D 1143. In which it said, well, we kind of got that wrong. They don't actually need admissible evidence at that stage to show the judgment would change. They need to make a prima facie showing that will allow the court to weigh whether there would be an injustice if the judgment wasn't set aside. So now the standard seems to be that if you come to court and are able to make a prima facie showing of a meritorious defense, the court should entertain that. Now, what I see most often happening is even attorneys who file a motion to set aside a judgment will say there is a meritorious defense, and that's it, leave it there. I still think you need to give the court some rationale.
On August 27th, 2012, the trial court granted Welton's motion for relief from judgment. Welton then filed an answer to Midland's complaint. Seems pretty generous by the trial court. Would you agree?
I don't know what the. I think Mr. Flora alluded to the fact that a lot of times, the courts are very deferential to defendants, and I think that's probably what happened here.
On September 14th, 2012, Midland filed a motion for summary judgment. On October 1st, 2012, Welton sought an extension of time to respond while discovery progressed and was given until December 14th. On December 13th, Welton sought another extension of time, specifically requesting that she have until January 14th to respond, and the trial court granted her request. So once again, more deference. Welton did not respond by January 14th, and on January 22nd, 2013, the trial court granted Midland's motion for summary judgment. On January 30th, 2013, Welton filed a second motion for relief from judgment under Trial Rule 60B1. The motion referenced the meritorious defense that the claim had been paid and explained that Welton's attorney had been in the process of forming a new law firm, and that through mistaken neglect and through some part of the new systems and procedures of the new firm, which was still being implemented, the response date in this matter was miscalendared for a date after the 14th, which appears to have been January 25th. Anything on that, Ian? Malpractice?
Yeah, I mean, I'm not
arguably.
gonna sit in front of a bunch of other attorneys and talk about malpractice, but I mean, I wouldn't want to explain that to my insurance carrier, that's for sure. And also, I mean, what's so interesting about the case you're reading today is the excusable neglect part is just not what is litigated very often in these 60B cases. Usually it's I wasn't served, I didn't know about it, here's
Okay.
this. I mean, having said that, I've seen some recently that start to fall in that category. I had a case where in the motion to set aside the excusable neglect went to the courthouse on a holiday and it was locked. Of course, this motion it was being filed 6 years later, so I'm not sure that in that 6 years that she's going to find another day to get there and get something in front of the judge.
I would warn colleagues that there's considerable amount of case law indicating that neglect by an attorney is not excusable in most circumstances. So
That's
aware
an
of it.
oxymoron, huh? Excusable neglect.
Yes.
After hearing, the trial court denied Welton's second motion for relief from judgment. Welton filed a motion to correct errors, which the trial court also denied. She now appeals. Analysis. Welton claims the trial court erroneously denied her second motion for relief from judgment, which was based solely on Indiana Trial Rule 60b-1. This rule allows a trial court to relieve a party from a judgment for a mistake, surprise, or excusable neglect, and requires the movement to allege a meritorious claim or defense. Any examples of meritorious defenses?
Well, I think Mr. Flora, I think the meritorious defense that was in fact put forth in this case is something that Mr. Flora knows about. I think it had to do with something with the court and satisfaction. In other words, I think they say that they
Right.
compromise the
Settle for a
claim
lesser
earlier.
amount. Okay.
This is something I used to see more of than I do now for whatever reason. There used to be more steps between the original creditor and the debt buyer that's filing the case. And along those ways, there were settlement offers that were made by intermediary companies. So when you'd get your bill of sale sheets in your case, you might see this started as Capital One and went through Sherman Originator 2 and Aero Finance 3 and something before it got to Midland.
Right.
And then we'd have more cases where people claimed that they paid off one in between. One thing is, and the reason why I think sometimes myself, well, mostly myself, has a little bit of a cross attitude about some of the 60B stuff is because the reality is with both counsel and pro se defendants, and this is also why I have a bad attitude about the shotgun approach to filing the response to the complaint. If you've got a real world issue in one of these cases, like you have paid off a settlement and you've kept some proof of that, or you're an identity theft victim or one of these things, not saying these never end up in front of a court, but if they're moving through litigation where there's a summary judgment and things like that pending, it's not doing defense any benefit by not disclosing all of that, getting all their information together and dealing with that informally. And I will tell you, 99 out of 100 cases that actually have identity theft or have paid to one of the previous in line debt holders or something like that get resolved without going to judgment or get a dismissal after judgment if they're appropriate. Obviously I know nothing about the defense in this particular case, but I think that kind of answers the question.
Yeah. The meritorious defense element requires a showing that vacating the judgment will not be an empty exercise. Outback Steakhouse. The burden is on the movement for relief from judgment to demonstrate that the relief is both necessary and just. DeLage Landon Financial Services. Our review of a trial court's grant or denial of motion for relief from judgment is limited to determining whether the trial court abused its discretion. Favorite word of judges. A trial court abuses its discretion when its ruling is clearly against the logic and effect of the facts and circumstances before the court. Welton contends she demonstrated mistake, surprise, and excusable neglect by explaining that the failure to respond to the motion for summary judgment was the result of a calendaring error attributable to her attorney while he was establishing a new firm. She also claims her first motion for relief from judgment demonstrated her meritorious defense that she paid the debt in 2010. Welton asserts that by filing the motion for relief from judgment, she simply was seeking the opportunity to respond to Midland's summary judgment motion where failure to do so resulted from mistake or excusable neglect. Although we appreciate Welton's predicament, the hammer's going to drop, we cannot say the trial court abused its discretion in denying the motion for relief from judgment. Excuse the typo. Generally, an adverse party has 30 days after the service of a motion for summary judgment to respond and file any opposing affidavits. However, for cause found, the court may alter any time limit set forth in this rule upon motion made within the applicable time limit, time rule or trial rule 56I. There is a bright line rule which precludes the late filing of responses in opposition to a motion for summary judgment. Mitchell Court explained now firmly entrenched as an article of faith in Indiana law. This bright line rule provides clarity and certainty to an area of the law which for too long lacked both. Ian Flora, anything on that?
Well, I agree. And in, this case where she had
You
a couple of,
agree?
with the Mitchell case, I think there does need to be a bright line on when your 56B response is filed by. And, because like in this case, she got multiple extensions of time. And I found that trial courts are always willing to give extensions of times with those without, unless plaintiff's counsel is filing an objection or something like that.
Did Ian
So,
Septoski anything on this bright line rule? All right. Our Supreme Court resolved the unsettled issue, whether a trial court has the discretion to consider untimely designated evidence when it's cited with approval, Desai v. Croy. When a non-moving party fails to respond to a motion for summary judgment within 30 days by either filing a response, requesting a continuance, or filing an affidavit, trial court cannot consider summary judgment filings of that party subsequent to the 30-day period. Question, is it just that the court cannot consider any filings, but they can still hear the argument and listen to the argument? Or is it, bam, you're cut off?
That's a very good question. And I seem to recall there is case law on that basically that if you're trying to slip in what would have been in your filing as an argument, you can't do that. But it should be kept in mind that you have to put forth affidavits in your response, and you have to present admissible evidence in response to a motion for summary judgment. And an argument in the hearing cannot be that. So I think the bright line is a firm bright line on that.
In Homack Servicing Court, our Supreme Court again addressed this issue and concluded that the trial court did not err in refusing to consider a late filed affidavit, given the express provisions of Rule 56 and the well-developed case law interpreting and implying it. Welton relies on the dissenting opinion in Desai, which states we should not interpret our trial rules so as to encourage trial courts to essentially enter default judgments against litigants who are able to show cause for their failure to respond within 30 days. Our Supreme Court clearly rejected this position when it cited the Desai majority with approval in Borsak. Any residual uncertainty was resolved in 2005, etc. Welton acknowledges this rule, but points out that this was not a case in which he failed to take any action within 30-day time limits of Trial Rule 56. She argues that because she tried twice to move and was granted extensions of time, the trial court's discretion to consider a belated response to Midland's motion for summary judgment was preserved. We are not convinced that our Supreme Court would favor such a rule. In Mitchell, our Supreme Court reconciled the 30-day time limit of Trial Rule 56 in the language of 54B, which explains that non-final judgments are subject to revision at any time. To harmonize the rule, the Mitchell Court held that although a trial court may indeed make material modifications to non-final summary judgment, it must do so based on the timely submitted materials already before the court. To hold otherwise would allow a party to avoid the strict timelines for designating evidence under trial rule 56 and would resurrect the uncertainty in the decide line of cases sought to eliminate. Ian Flora, anything on that?
No.
Ian Septoski?
No, I think that, yeah, I think that's square.
Mr. Barnes got it right.
Yeah.
We believe the plain language of trial rule 56I allows a trial court to alter time limit if the motion for extension of time is timely filed. It does not vest the trial court with discretion to allow a party to file a untimely response simply because he or she had not previously filed a timely motion for extension of time. To hold otherwise would create the very uncertainty our Supreme Court sought to avoid in Mitchell. Even if Welton's motion for relief from judgment had been granted, Welton would not have been permitted to belatedly respond or designate evidence in response to Midland's motion. Without a response, it's hard to imagine how the outcome for summary judgment would have been different. Taking this with the fact that the trial court has already granted Welton's relief from judgment once, and the fact that Welton specifically asked for and was granted an extension of time, but still did not file a response, it leads us to conclude the trial court did not abuse its discretion in denying her second motion for relief from judgment. Ian Flora, anything on that?
No, I think the Court of Appeals got it right. And, ultimately, it's not real clear which one of the excusable neglect or mistake you want to call this from the attorney that didn't timely file her responsive pleadings, but having got an extension and moving offices obviously isn't good enough for the Court of Appeals. And I'm not particularly sympathetic here. I think if she'd have been at all on top of her case and reaching out to opposing counsel, I mean, one thing is, being the person that's often opposing counsel when these things happen. I mean, we're pretty understanding if you're trying to work with us. I mean, it doesn't benefit us or our clients to spend a lot of time in the Court of Appeals litigating 60B motions on a case that could have just went to trial and been over and done with before this. And it just also highlights the fact that, this isn't how attorneys treat one another, that when somebody's missing a deadline or something and they reach out to you, I think it's incumbent upon us to afford a little bit of grace. And it looks like here the trial court afforded a lot of grace and ended up having to get everything they did reviewed by the Court of Appeals. So
grace is good. Ian Septoski, anything?
In the collections attorney world, I think this is an extremely important part of this decision, because in our world, unlike probably in the vast majority of cases, when you file a motion for summary judgment, it's not likely that a pro se defendant is really going to be able or will respond to your motion for summary judgment. And so the vast majority of those cases are being decided without any filings or affidavits put forth by the defendant in our cases. And so if that were to go up on appeal, I think the important part of this decision is that, well, in that circumstance, even if we were to grant the motion to set aside, that party still wouldn't be able to put forth a defense at the trial court level. So what's the difference? But again, I think this is kind of limited to a situation where you've got a uniquely where the party didn't respond to summary judgment at all. I don't know how often that really happens outside the collection world that we're involved in.
Good, thank you. Welton also challenges the merits of the trial court's grant of summary judgment in favor of Midland and asks us to review the grant of summary judgment de novo. She relies on trial rule 1, which provides that the trial rule shall be construed to secure the just, speedy, and inexpensive determination of every action. Trial rule 1, you got to be kidding. Ian Flora, what's your take?
I think it's
The last
reach to
refuge
cover
of
malpractice.
attorneys who miss deadlines, trial rule 1.
I wasn't aware.
I think maybe what else there's. I think what this attorney might be missing that is, if you've got real evidence of the accord and satisfaction issue, the having paid in 2010,
Produce it,
it doesn't matter as your defense any longer that you blew this case and lost a money judgment. You have a plaintiff's cause of action at that point. File a separate case suing under that, and handle it that way if that's a real thing. Because, I think so much of what myself and Mr. Septoski sees is that when people are responding to summary judgments, it's, behind the scenes, these are just kind of stalling, delaying tactics that usually end up eventually with some kind of settlement. Yeah, and for cases that end up with settlements or agreed judgments, especially because so many of them, as Mr. Septoski said earlier, come out of these debt buyers. If you're sitting and you're watching the Bulls game, and you'll get commercials for American Debt Relief and all of these companies representing, that they're rainbows and puppy dogs and get all your wishes come true if you just give them your bank account routing number. But in reality, their clients are getting sued, and the way they handle that is contracting with a rental license in that state and filing these form pleadings. Okay. So much of what we're seeing are just these form pleadings clogging up the system to slow down the lawsuit one while they accumulate money to do the settlement issues. And
or file bankruptcy.
Yeah, and as I kind of said earlier, that when folks have real defenses, even as plaintiff's counsel, you end up in a position where you're accumulating that information and stuff for them to get in front of your clients, because if this is an identity theft case, et cetera, they're just resolved without going to trial and having to tell that to the trial court judge,
Okay. Walton contends that although she could have appealed the entry of summary judgment, she chose a less expensive and more efficient route. On appeal, Walton asserts the trial court abused its discretion, denying the motion for relief from judgment because Midland did not make a prima facie showing that was entitled to summary judgment. Regardless, a trial rule 60B motion is not a substitute for direct appeal, not intended to address the legal merits. Even with the dictates of trial rule 1 in mind, Indiana appellate rules govern procedure for appeals. If a notice of appeal is not timely filed, the right to appeal shall be forfeited. Conclusion: Walton has not shown the trial court abused its discretion in denying her motion for relief from judgment. Walton's challenge to the underlying grant of summary judgment for Midland is not available for our consideration. We affirm. All right, we are at the end of the case. Want to thank the Ians for participating and for giving your insights. I believe Ian McGuire wanted to make a pitch for the appellate court coming.
Quickly, did you want to take any questions or not?
Yeah, if there's any, I have a 1 o'clock hearing, so I'm under the gun here, but if there's any questions, quickly.
Anyone have any questions? I know there was something in the chat. I think it was sort of addressed.
Well, that was my question. This is Drendel, as somebody who represents debtors mostly. Panelists accepted. There are some collection attorneys that are filing in CC court outside Marion County for reasons that I think are to present unsurmountable procedural hurdles to debtors. I get debtors in my office that say, I got these court papers, but I was looking for the court date. I didn't find the court date, so I could show up and explain why I didn't owe this amount or didn't owe this debt. And of course, in plenary court, there is no date set. So they can't navigate that. They certainly can't navigate summary judgment. But small claims gives them an opportunity to talk to somebody. Pro se.
Yeah, I would push back a little bit on that and say that they were doing that in a way to maybe get one over on the defendant. I will tell you that my office does that. We don't file in small claims court outside of St. Joseph County or some other local counties, only because logistically, if I'm filing in small claims court down in, I don't know, in Kosciuszko County, for example, that means that I've got to travel to go to a hearing in small claims court. And so, just logistically and expense wise, it doesn't make sense. That's why we file in upper court.
Yeah, Mr. Drendel, I've known you a long time and respect you, and I think you have my contact information, and I could talk to you about this very issue for hours. But as someone who's been involved in that decision across the state and why they're doing it, it's never once been an issue of because we're trying to make it harder on the defendant. It is always has to do with money. Like our clients, it's a very thin profit margin. That's why they do it in bulk to get what profit they do out of it. And literally the extra amount of paper that it takes to file in small claims, they having to send myself or Mr. Septoski to one more round of hearings than you have in the CC courts. Those are the deciding factors. They literally have no thoughts to any individual. You know, I mean, granted, if you've got local chip and seal, did somebody's driveway, maybe they are, but in the stuff that we deal with, you know, Capital One Bank, Discover Bank or something, they don't care about any individual consumer in a negative way to file in this court over that one because it's more inconvenient for them.
I've known you guys for a long time, you two. This was not a high volume collection attorney.
Sure.
Yeah. Anyway, put my 2 cents in.
Thank you.
Thank you.
Okay, the quick pitch I was gonna make is we're doing the Court of Appeals on Monday. Mondays are always tough, so I wanted to remind people that we're doing that. The Court of Appeals is arguing their oral argument at 10:30, and then we have a CLE immediately following it. The topic of the CLE is demystifying the judicial selection process. They're really hoping with the retirement of the 2 appellate court judges to find somebody from our area. So that's part of the reason why they are doing that here. So either come or RSVP. I'll be sending out an email in just about an hour reminding everybody about that. So thank you to our speakers. I think Telloyan jumped off. I do see there's another question in the chat. It's not brief, so I didn't want to read it quickly, but I don't know if you want to look at that and address it. It's up to you. I know we're past our time. So I did get everybody in the group. We went through and able to check everybody off that had RSVP. So, and a few of you that hadn't. So I think we have you all accounted for.
Okay, yeah, I'm kind of reading the question that Kristen asked, and I think unfortunately we're kind of at an end here, and I need to get into another courtroom. But I do believe she has my contact information. If she wants to reach out, I'm available, and that's true for anybody else.
Thanks very much.
Thank you very much. If anybody has any other questions, I'll be on for a few minutes if you need anything.